Okay, good evening. This is a workshop between the Selectmen and the Planning Board to discuss proposed changes that the Selectmen are putting forward to go on the town warrant this June. We've asked Joe Lunkowski, the town attorney, to be here. He's helped the Selectmen in writing up this proposal. And if, Joe, if you would, explain what we're doing here.
Yes. My understanding of what the Selectmen are attempting to do is to deal with input that they received from, I guess, a fairly significant number of citizens of the town after the most recent zoning amendments went into effect. There was a feeling that perhaps, based on that input, that there was a less than complete understanding among the voters and the citizens of the town of exactly what the effect of the zoning amendments were going to be. The board felt that it would be appropriate to give the citizens another look at this issue now that they had lived with the amendment for a period of time. And that's what the proposal is intended to do. It's not proposed, we're not intending to take any particular position. It's just good, there will be an opportunity if the amendment proposed by the board or intended by the board to go on to the warrant. What it will do is it will give the people who are there to vote in that town meeting a clear choice between continuing what they've got, if they're happy with that, or to go with a less restrictive version that still complies with the state of Maine guidelines. And that basically is all that we are attempting to do at this point.
Okay. This is not a public hearing. It hasn't been advertised, so we're not going to be able to allow the public to speak tonight. We will be having a public hearing on this issue where anybody that wishes to come in and speak for or against this issue will be welcome to. And also, of course, this can also be argued on the town floor. So if you folks have any other questions for the Selectmen or Joe, that's the Planning Board, then we'd be happy to answer them. Yeah.
Ted, can I just give a little background as to...
Yeah, no, we're not going to do that here tonight, Tom. We're just showing what we're going to do, and you can argue your side, your position at the public hearing or at the or on the town floor. We're not going to debate the issue here tonight. If you have any particular questions as to how it's written, why we did it, or anything like that, we'd be happy to answer them, but we're not going to debate it tonight.
This is not a debate. This would be an explanation for...
Yeah, well, we don't need to explain it tonight, because we're going to do that at a public hearing, and I'd be more than happy to give you all the time you want at public hearing.
Okay.
Okay?
Ted?
Anybody else? Yeah.
Can you explain to me what your definition of a workshop is, then? I'm not quite sure why we're here.
We're just really here as a courtesy to let you guys know that this is what we're planning on doing. And then when we go to public hearing, then we can debate the issue. We don't want to debate it here tonight because we did not advertise it to the public, so the public can't be here to be part of the debate.
But I thought it was a workshop between the two boards.
Well, just for us to explain to you what we're doing. So if you have any questions about what it is or why we're doing it, then we'd be happy to answer those. But to debate the issue, we'll wait for for a public hearing to do that.
Can I keep going with my thoughts?
Yeah, sure.
Are we in agreement that it was the Selectmen who tasked us, the Planning Board, to come up with some changes to this part of the ordinance?
We had asked the Planning Board last year to do what we have done.
Right.
And we don't feel that's what the Planning Board has done. So we're going forward with what we wanted to do last year. And you did come up with some changes, which will also be on the warrant. We're still putting your changes on the warrant also. So the town will have the opportunity to choose whether to approve or deny your changes and to approve or deny the Selectmen's changes.
Suppose they could take our, what we're proposing and add that into what they had and change theirs around. If you wanted to do something like that, but.
What constitutes a not insignificant number of citizens?
What's happened is we've had quite a few people come in even before this year, that have gone to Ken, and Ken can probably tell you better how many have come, and found out that land that they had purchased for a particular reason now was no longer buildable. One in particular was they bought a lot 30 years ago, 5 acres with, or 20 years ago, with the plans of building a retirement home. Now they've come up to build a retirement home, and that lot is no longer buildable. And they've been paying taxes as a buildable lot for 20 years. And, you know, that's one of many that have come in that we're finding that that's happening, and that's why we wanted to bring it to the attention of the town. If that happens and we leave it the way it is, the tax base is going to change with each and every one of those landowners coming in and trying to apply for a permit. We're going to have to, you know, change the valuation, and we've had to change several already through the O'Donnells. People have come in, found out they couldn't build, and then we had to give you know, we had to give abatements, and, you know, so the whole tax base will change once these people find out that their lots are no longer buildable. And they're not finding out until they come and see Ken. And we're just going with the state standards is what we're asking the town, if they want to go with the state standards or leave with the more stringent requirements that the town has. Yeah.
Ted, in all due respect, it is a little heavy-handed, I think, to not allow us to at least explain to you folks and to those present why the initial proposal that you made a counter-proposal to, if I'm correct, so that this is not debating anything, this is just stating factually as to the origins and the thinking behind the planning board proposal, I would suggest.
I don't think this affects what the planning board is proposed. You're giving the whole area the opportunity to come before the planning board to have lots looked at one at a time. We're taking lots that are not in shoreline and putting them to the state standard instead of the town standard. So the two different changes, the ones that the planning board have and the ones that the town have, are different. They're not the same thing.
I understand that completely.
Right, so they're going to have the opportunity to vote on all three of them, R2 and your one.
Well,
We can, like I said, tonight's not to debate the issue because we didn't invite the taxpayers to the meeting. We did not advertise this meeting because we're just here to tell you why we're doing it and to, if you had any questions for Joe, who helped us, you know, write the document, then that's what we wanted to make available to you. And then, public hearing, anybody can talk about anything that they want to talk about with this issue.
well, if I may continue?
Yeah.
It would seem then that the thrust of your perception that this proposal needed to be, the original proposal by the planning board, needed to be modified, if I'm understanding Joe correctly, arises primarily from an economic perception, and not so much whether or not this will enhance the existing functions and protections and benefits that wetlands provide to our town.
What our proposal is for is to allow the town to understand what's happening with this land, because we've been living with this zoning for a while, and now it's coming to the attention of a lot of the taxpayers that their land has been affected where they may have not known that before, and then the town gets to make the decision on whether that they want to change it or not. We're not saying that you should go with the planning board's recommendations, or you should go with the selectmen's recommendations. We just want you to know what we've discovered and what has happened with this different lots going into the valuation going down. What will happen is if everybody that's in this area comes to the town and has their valuation changed, then even if the budget for the school or the town didn't go up, everybody's taxes could go up because the valuation on all those properties that are no longer buildable is going to change the tax base. So that's all we're trying to get across to people, and then they can decide. This zoning was only passed by 2 votes. So we're giving the town the opportunity to look at it again and decide what they want to do.
I think that's incorrect, the 2 votes. The meeting in 9/29/11, at which point these proposals were enacted by the town or adopted by the town, was a almost unanimous vote. The 2-vote margin that you speak of
Was the actual town
Was
election.
the meeting at which the town accepted the comp plan implementation goals, the comp plan itself, that we were battling a developer at the time who was very actively opposing anything that would infringe upon his rights to do anything, and he was able to muster some malcontents, I don't know what you want to call them, but the margin of the vote at that point was very narrow, I agree.
Yep.
But I think...
And that was the town vote, Tom. That's the taxpayers voted.
Correct.
Right.
But the vote at which these, at the time at which these measures that the comp plan committee and the planning board endorsed and moved to the voters was on 9/29/11, and at that point, the vote was almost unanimous.
Not by the voters of the town.
Yes, sir, it was.
Off the top of my head, I mean, Mr. Cashin is referring to a special town meeting that was held in September 29th, because he asked me about this recently, so I have it somewhat fresh. And as I told him, at an open town meeting, unless the moderator requests a hand count, there is no count given. So, you know, a majority in favor, and then opposed. So I think it's impossible without somebody watching the tape to determine, you know, whether it was, you know, overly unanimous or not, or close. The moderator made a decision that the article passed. I mean, that's the most that I can say without watching the tape and trying to count the hands that are up, because we do not count.
Okay, but the two votes were on, the passing by two votes was on a ballot, correct?
It was on a ballot question. I would have to pull the ballot to see exactly what the wording was.
Okay. So all we're doing is we're presenting the issues that have come before us to the town and letting them decide if they want to keep it the way it is or if they want to change it. And that's all we're here for.
I don't want to do all the talking tonight on behalf of the planning board. The planning board has already voted on, and I think it was a unanimous vote, to endorse our proposal, to which the board has seen fit to make a counter-proposal. I would question one procedural point here, a number of procedural points. Why did the board feel that this apparently has some kind of an emergency nature to it, which necessitated going around the normal procedure that I have encountered when I go in with a notion before the board that I would like included on the warrant, and I was politely told, respectfully, in order to give more merit to the proposal, would you please come back to us with a petition of a listing of concerned citizens that make the...
Where did you hear that
Proposal.
from? You didn't hear that from the selectmen?
I heard it from, most recently from yourself, when I came
I didn't
into
ask you
the
to come with
office.
a petition.
Let me finish, please. When I came into the office proposing to put a petition in front of the voters pertaining on the referendum warrant pertaining to the climate change consideration. And
The climate change, what does that have to do with why we're here tonight?
None whatsoever. I'm
Okay,
just...
so that's a different issue.
No, Ted, listen to me, please. I'm saying that there's a different procedural conduct going on here with this proposal, which ostensibly has come from citizens who are upset with the planning board proposal and zoning in general regarding resource protection.
Okay.
When I have asked in the past, and when other voters have asked in the past to put an article on the warrant, you have said to me personally, on one that I have been involved with of late, please, it doesn't matter whether we're in opposition or in agreement with you, would you please, if you want to move further with this, get a petition of whatever it is, Jennifer, I don't remember, 10% of the last voters in the gubernatorial election to confirm that this is indeed an article, a measure that merits consideration by the town meeting.
And you're right, and I did say that to you, Tom, on that issue. But this is not us putting this forward for people that came to us with these complaints. This is the Board of Selectmen, because we've had to give abatements, and we've had to talk to our assessors, and told us that this is an issue, so the Board of Selectmen has decided to put this forward. So it's coming from the Board of Selectmen, it's not coming from concerned citizens that went in, because what they did is after they found out they couldn't build, they went to O'Donnell's and they got an abatement, so they got their taxes lowered. Our concern is the tax base, because this is going to grow. As people go to get permits and cannot get them, then there's going to be more and more land that is not going to be buildable, and that's going to have to come off the tax roll. So the selectmen are putting this forward with a concern that the tax base will change, and the town needs to know what we know so that they can make an educated decision. So that's all, that's the only reason we're putting this forward. This is not coming from the concerned citizens, this is coming from the Board of Selectmen, which is in the ordinance that we're allowed to do this.
I understand that, that you certainly.
And this isn't new, Tom. We were going to do this last year. We talked about this last January. We were going to put this on last year's warrant, and then we discussed it, and we decided that, okay, the planning board sees what we're talking about, and you're going to discuss it, and you're going to come in with some changes. And you came in with changes, but not what we felt we were looking for, so we've decided to ask our own question, and we're entitled to do that.
May I continue?
Yeah.
Oh, I'm sorry.
Ted, do you have a particular objection to the way the planning board is addressing this with, within shoreland and resource protection outside of shoreland and separating those?
Well, we're going for the outside the shoreland, the resource protection areas that you have outside the shoreland, because what you've done is, you didn't have before the option, I mean, when these folks came in, they didn't have the option of going to the planning board. All it was, okay, you're in the resource protection, the new one.
Sure.
So you can't do anything.
Yep.
So you guys have opened it up that now they can come before you and go for, your approval to go out and look at the lot and say, okay, yeah, we can do something here, here's the best place and everything else. We're not trying to get into the shoreland resource protection. We're just trying to get into the rest of the town that doesn't affect the shoreland and give them the right to come to Kenny or to our code enforcement and let Ken decide, because of all the other zoning that we have, with the way that wetlands are, the guidelines for the wetlands and everything else. I mean, we're just doubling up all these extra restrictions, when if we just go by what the state is recommending, it opens up those people to go to Ken, and Ken make a decision on the best place, whether it's appropriate to build there, and then they can't come to the town and say, okay, my land is now in resource protection, I can never build there. Because the same thing will happen is if they come to you and you tell them, no, that, we've looked at it and we've decided you can't do it, based on the zoning we have now with the 2 acres instead of the 10 acres, then the same thing will happen. Their land will now be lower value, and we'll have to give them abatements and lower their taxes. But if we go to the 10 acres, it gives Ken a lot more options to approve building on that land. Am I correct?
Well, in the current proposed amendments, there's no proposal to change the 2 acres to 10. There's 2 different issues here. The wetland definition in the state model ordinance is 10 acres of wetlands. Our definition of wetland is 2. So that's the overall definition. So there's really nothing going on here, 2 versus 10, in anything that we're proposing.
Okay.
The 2 proposals that the selectmen are putting forward, the first is to, right now, under the existing ordinance, any 2 acres, contiguous acres of wetland is in shoreline protection, regardless of where it is in the town. And what the amendment the selectmen are proposing would bring the Acton ordinance into conformity with the state model ordinance, so that it's the 2 acres of contiguous wetlands that are going to be in resource protection are those that are in the shoreland zone. So it's not going to affect the definition, the Acton's definition of what a wetland is. That's still going to be 2 acres as opposed to 10.
Ted,
Now I'm confused.
on the outside chance that it happens, how do you guys deal with, or maybe it's a legal question, both of these passing at the same meeting, when they don't seem to be the same?
Theirs is just allowing the people in the shoreline to go before, if we changed the, yeah.
Yeah, it's, that's a good question. I think that the answer is that if the selectmen's proposal passes, it's going to subsume the planning board's proposal. Because the planning board's proposal deals specifically with allowing building in a resource protection zone if certain criteria are met. And the planning board's proposal restricts that to resource protection areas outside of the shoreland zone. So if the selectmen's proposal to basically eliminate resource protection areas outside of the shoreland zone passes, then there's not really going to be anything for the planning board's proposal to reach.
Mm-hmm. So the only purpose, I guess in my mind then, would be if the planning board's proposal was to go forward, would be if the selectmen's was first denied.
Right.
I think that's accurate. I think it's possible that well, again, the selectmen have two proposals. If the one to remove resource protection areas entirely that aren't in the shoreland zone, then the board's amendment is moot. However, if, let's say hypothetically, that they vote to say, no, we don't want to eliminate, we want resource protection to be anywhere, we want it to be like it is now. Anywhere there's 2 acres of wetland, we want that to be resource protection. Now you've got two competing ordinances or amendments as to where you can build if you get permission. Because the planning board's proposal says we only are going to allow ourselves, if you will, to give permission to build if your resource protection area is outside of the shoreland zone. The selectmen's proposal mirrors the provision that's in the state guidelines, which is any resource, you can build in any resource protection zone if you meet the criteria that, or I should say, the planning board can give permission to build in any resource protection zone if the criteria is met. So those two that are very similar are still, the selectmen's proposal is broader than the board's proposal.
Yeah.
Not to muddy the waters on this conflict that may or may not arise, but I would think if you check on, in our ordinance 5.23.14, conflict with other provisions, if both measures were approved by the town meeting, the more stringent of the two would prevail, which I think would be the planning board's. And if I may raise another point of clarification.
Sure.
The planning board proposal merely gives a conditional review process to those resource protection areas that it wished to retain outside of the shoreland zone. When we were considering resource protection areas in the shoreland zone, and those are large, generally 10-acre plus wetland areas that feed directly into our great ponds. Our thinking was we have exceeded greatly, probably, the natural carrying capacity of our great ponds by the level of development around the perimeter of these ponds. And to allow any further building density proximate to our great ponds, especially in fragile areas such as resource protection, runs
Again,
totally in conflict with the notion of protecting our water resources, which,
again, this is for a public hearing, and you're going to have one too. I mean, you guys will have one on your amendment, and we'll have one on ours, and that's the time for that kind of discussion. Not tonight. We're just here to tell you what we're doing and why we're doing it.
well, hopefully we were here to raise some points to condition your thinking. But such is not the case.
No, we've decided we're putting this on the warrant this summer already. And then it's up to the town to decide. So at a public hearing, you can bring all these points up at yours and at the one that we have.
So my query to you pertaining to the procedural issue of why a petition was never necessary by those voters which were aggrieved by the existing status of things, of the existing safeguards for resource protection, or wetlands, that has no bearing because you apparently listened to the advocates that wish to rescind these safeguards, and then by some process.
No, that's wrong, Tom. Again, I'm going to tell you, once they came in and this was brought to our attention, we then had people coming forward and asking for tax abatements that we had to sign. And some of them were several $1,000s. So that's what brought it to our attention, and that's the issue that we have, and that's why we're bringing it forward to the town. It has nothing to do with the fact that some people came and tried to get a permit and couldn't get a permit. It's that some of those people also came and went to O'Donnell's and got their tax valuation on their property lowered, and there's a lot more people that can come forward with that issue. So that's why we're bringing this up. That's the only reason. It has nothing to do with us going around the petition process because these people were unhappy they couldn't build. We're concerned that there's going to be an issue with tax valuation in the town of Acton if this stays the way it is. And that's all we want to bring up, and then the town has the right to vote, yes, keep it the way it is, go with the planning boards. We're just asking the town, they're the governing body. So we're asking a question, and that's all. We're not going to try and convince anybody to go either way, that's up to the town vote.
Well, Ted, it would seem in the abatement process, in the granting of these abatements, a value judgment was made that the argument of the applicant in hand, who came to you with a grievance, carried more weight than the town vote, which they were aggrieved with.
I don't understand why you're afraid of asking the question when we have information that we didn't have at that time.
I'm not afraid of anything.
Because that's all we're doing, is asking the town what they think, knowing what we know now that we didn't know when we put the zoning into effect.
Well, it's puzzling to me a little bit that neither the planning board, except through the agency of Kenny, who warned us that there was some pushback in the wings on this, and we thought we were acting in response to that when we crafted our measure to address this. Why no one, prior to our public hearing on our proposal, appeared before the planning board, nor, as far as I know, no one ever went before the Board of Abatement Review. This was totally
Because
conducted.
it was recommended to us by our auditors, our assessors, that those properties their valuation need to be changed. We hired them because of their experience and their knowledge, and when they tell us that a property should be changed, then we change it.
Was the notion ever raised within discussions that there were a finite number of these properties that existed, and this was maybe just a winnowing process, and which would be winding up as soon as these grievances were addressed?
No, because the more people that come forward to build in the future, I mean, this is just happening recently, the more that come forward in the future with the same thing, is their valuations are gonna have to go down. I mean, when you have people from out of state that bought land 20 years ago, and then they're gonna build their retirement house, they finally come up to build their retirement house, and they've been paying all these taxes on this land for 20 years, and now they can't build their house. I mean, there's a lot of lots like that, and that's what's happening, and that's why we wanna ask the question, that's all. We're not trying to make it, unsafe for the lakes or change the water value, or we're not trying to go around. We asked the planning board last year to do this. This is what we had heard last year, so this is over a year now. And what you came forward with is not bringing up the question, not answering the question that we have with all these tax problems. So we're asking the town if they want to change the zoning so those properties stay at the valuation that they have now.
The planning board has no business, we have to take issues like valuation changes into account, and we have done that, as you might be aware, during the process of the implementation of the comp plan goals. We did meet with the assessor, and we had quite a rigorous process of, there was a fact sheet, Jennifer probably remembers this, that was circulated, I think, to all the voters of the town. And there was certainly a full, probably more so than any other issue that ever has come before the town, notification, discussion, and debate of these proposals that are now proposed to be completely rolled back.
Okay, and those are all good points that you can bring up at a public hearing.
Okay.
Okay? Anything else?
Is there a way in which, by the time we get to the meeting in June, that the numbers that you keep talking about, seemingly vague, of people who have had issues with the changes, find out that they no longer can do that, and the dollars that we're talking about that impact the budget, will those numbers be available to us at that meeting in June?
O'Donnell's will be able to do with the map, right? We have a new map made up.
So that question
we
coming up
can have
would
O'Donnell's
actually be answered with concrete numbers.
from our assessing.
But at the meeting,
Yeah, we can have it for the public hearing.
at the public hearing.
Yeah.
Come before the summer.
Before the town meeting. Yep. Okay. Anything else? Thank you, sir.